Being aggrieved, the private respondents filed a revision before the Deputy Director of Consolidation under Section 48 of the Act 1953, who vide his judgment dated 25/6/2002 upheld the order of the Settlement Officer of Consolidation on the ground that a preliminary decree is a final determination of the rights of the parties in respect of the property sought to be partitioned. It is also appealable, but no such appeal was filed by the petitioner herein, that is, respondents, before the revisional court. On the allegation of fraud, the court perused the courts and found that there was no pleading containing requisite denial of thumb impression, nor the presence of the concerned in the court, etc., nor evidence to prove any such fraud. The revisional court relied upon the decision of the Supreme Court reported in AIR 1995 SC 2493 Mool Chand and others versus Deputy Director, Consolidation and others, to hold that a preliminary decree passed in a suit for partition under Section 176 binds the parties even if those proceedings do not result in a final decree, if the said preliminary decree is not challenged in appeal. Therefore, the preliminary decree dated 1/3/1986 passed on the basis of compromise, which had been duly proved, was binding upon the partitions and also operated as estoppel, and principle of acquiescence also applied. Stanza. The contention of learned counsel for petitioner is that no such compromise was entered into with the private respondents, and he had no knowledge whatsoever about the said preliminary decree. Once the suit abated, the preliminary decree could not have been appealed, as any proceedings could not take place before the consolidation authorities. Plea of a fraud was taken before the consolidation authorities, which was found to be correct by the settlement officer, consolidation, and rightly so. There was no reason for the petitioner to enter into a compromise relinquishing 1/3 share and accepting 1/6 share of the holding, but the revisional court, without appreciating these aspects of the matter, has erred on facts and law in upturning the judgment of the settlement officer of consolidation, causing prejudice to the petitioner. Stanza. Sri V. K. Singh, learned counsel appearing for private respondents, has relied upon the decision of the Supreme Court in the case of Moolchand (Supra) to contend that preliminary decree prepared in regular suit under Section 176 for partition / division of share, which had not been appealed, was binding upon the parties and had to be given effect in consolidation proceedings between the parties. Therefore, the revisional court had adopted a correct approach in deciding the matter. He contended that there was no pleading whatsoever of fraud, nor was it ever proved. On the question of variance of shares contrary to what the petitioner was legally entitled, the pedigree being admitted to the parties, he placed reliance upon the judgment of this court. Report in Srimati Manrazi versus Deputy Director of Consolidation and others 2010 (1 ADJ 249 stop.